Good morning. Can both attorneys hear me?
Yes, good morning, Your
All
Honor.
right.
Jeffrey Kirkham, I can hear.
Great. Good start. Welcome to this oral argument session of the 6th District Court of Appeal. Just a reminder that we are being recorded and also simulcast on YouTube. We have one case on our docket today. It is 23-2119, the City of Naples versus Heidi Wolf and Joseph Wolf. Appellant's counsel, how much rebuttal time would you like?
5 minutes, Your Honor.
Okay, great. The timer will reflect that, and Mr. Hercombe, you may proceed when you are ready.
Thank you. Good morning, Your Honors. May it please the court. My name is Jeffrey Kirkham, and I have the privilege of representing the appellant, the City of Naples, in this appeal. First, let me thank you all for granting our request for oral argument and for your time and attention with respect to this appeal. We are asking this court to reverse the decision of the trial court that found that appellant's motion for trial de novo was untimely because the trial court did not have authority to extend the 20-day deadline. As a brief background, I know Your Honors have read the statement of facts for this, but this arises out of a non-binding arbitration that occurred on August 10th, 2022. The parties attended, and after that completed, a non-binding arbitration award was issued by the arbitrator on August 22nd, 2022. Shortly thereafter, the appellant, the City of Naples, filed a motion for extension of time, requesting that the court enlarge the 20-day period in which to file its motion for trial de novo, because the city, as a governmental entity, is required to hold a council meeting in order to review and evaluate the arbitration award and decide whether it will be accepted or rejected. That hearing—
And that was referred to the magistrate, correct? You didn't file it with the magistrate. The trial judge referred it to the magistrate?
Correct, Your Honor. There was an agreed order of referral from the court and the parties that gave the magistrate the authority to hear the motion for extension of time. And that
I do have one question. I think we're familiar with the facts. I don't mean to interrupt, but I
Oh.
do have one question. If we were to find in your favor, would we have to certify, or could there be conflict with the second district's opinion in the Gambrel case?
Absolutely not. The issues before your court are distinct and separate from any of the issues in the Gambrel case, and there can be harmony found between whatever the court rules today and the holdings in Gambrel such that they will not be disturbed. Going specifically to the Gambrel case, since Your Honor is obviously focusing on that, the issue in the Gambrel case was a very specific issue. The issue before the Second District Court of Appeal in Gambrel is when a motion for trial de novo is filed after the 20-day period and no party files any motion directed at the judgment or the motion for trial de novo, can the court hear arguments and issues as to whether or not the court has to enter a final judgment pursuant to Rule 1.280. And the Gambrel court said the court has no discretion. If nobody files anything and the 20 days pass, the court must enter final judgment pursuant to 1.280. But the Second District Court of Appeal understood the ruling it was making and specifically called out later on that the court was not hearing whether or not a 1.540 excusable neglect motion could be filed to set aside the final judgment. The court pointed that no such motion was filed, and though arguments had been made by parties to that effect during the hearing, without the invocation of a rule of civil procedure, the trial court would have been without authority and power to make any ruling on, for example, excusable neglect in the Gambrel case. The appellate court then went on to cite the case law that specifically states that the trial court cannot consider that, and called out that the issue of whether or not a rule of civil procedure, in this case 1.540, could affect an arbitration award was not before the Second District Court of Appeal. Refocusing—
Counsel, you can see, however, that the trial court had the power to deny it if they had so chosen by when it was initially filed. the court could have determined, and it would have a completely different standard of review for us. Is that correct?
Just a clarification, Judge Stargell, are you asking me about a 1.540 motion or a 1.09?
1.09. Oh, if it was properly before the court and they had denied it, we wouldn't have de novo review, correct?
Again, it's just a clarification, Your Honor, it's about the 1.090 motion for extension.
Yes.
Your Honor, if the court decided that the 1.091 motion for extension was not did not have a basis or should not be granted, then correct. That motion for extension in and of itself would not be appealable. Obviously, Your Honors would hold any jurisdiction and authority to review a final judgment in the capacity of reviewing a final judgment. But the specific issue that's before the court today, whether 1.090 can grant an extension, would not be before you because the court will have ruled specifically on that motion.
So this, your position hinges strictly upon the fact that the trial court ruled that they didn't have authority, correct?
Yeah, exactly, Your Honor. We are strictly here on the question of whether the court can even consider a 1.090 motion. And the case law and the issues before us show that the court absolutely can, as I will get to in a moment. But to go back to Judge Wozniak, I want to finish addressing your question on Gambrill to specifically conclude on that by the Gambrill court calling out that no motion was filed and that issue was not before it, it did not address the question of whether a trial court has authority to consider motions directed at an arbitration award. With respect to whether the court has authority to look at an arbitration award and whether the rules of civil procedure can apply to it, I believe it would be helpful to just briefly walk through each one of the rules we're dealing with here and how they interact together. First, we have Florida Statute 44.103, subsection 5. And in summary, it says that an award will be final if a request for trial de novo is not filed within the rules promulgated by the Florida Supreme Court. In that regard, the statute then directs itself to all the Florida rules of civil procedure, does not limit or focus on a specific one, and references us to them. We then move on to Rule 1.280H, which states, in summary, that if a motion for trial is not made within 20 days of service on the parties of the decision, the court shall enter such orders and judgments as necessary to carry out the decision. This is a straightforward rule of civil procedure, and it looks like many of the other rules of civil procedure we deal with. For example, this language looks very similar to the Rule 1.140, A1 rule, the defense rule, that states that a defendant must serve an answer within 20 days after the service of original process. There are many rules of civil procedure that utilize the rules shall and must to compel an action on the party. The last rule I want to draw attention to is Rule 1.090B, and paraphrase that says that when an act is required by the rules of civil procedure, the court may order the period enlarged if request for enlargement is made before the expiration of the period originally prescribed. Again, we have clear, unambiguous rule of civil procedure that said when an act is required, so we are invoking the shall and must language of the rules. When it is required, the court can enlarge that period. So when we read all three of these rules together, we see that the 20-day deadline imposed by 1.280 is a deadline like many others in the rules of procedure. And that 1.090, which addresses and acts on must and shall language, can enlarge the deadline in which you have to act before the ministerial and subsequent acts are required after the deadline is expired. Now, the real question we have before us here today is non-binding arbitration special? Is it immune to the rules of procedure? And does it have to just function on its own without any interaction by the court? And we know the answer to that is no. There are many cases that interact with there are many rules and cases citing those rules that interact with the non-binding arbitration rules and allow the judge to address the award or the time period for the award as needed under the rules. A clear example of this is the Harold versus Sanders case, 159 Southern 3rd 338. That's a second district court of appeal case in which an arbitration arbitration award was issued, but it was mailed to the parties. Within 20 days, the parties did not file a motion for trial de novo, and the court, under its own auspice, entered the final judgment pursuant to the non-binding arbitration. However, within 23 days of issuing the award, a party did file a motion for trial de novo and specifically pointed out to the court that because the non-binding arbitration award had been mailed, that Rule 1.090 applied, and it triggered an extension and enlargement of the deadline due to service under mail of 5 days. The trial court said, no, I have no leeway. The 20 days is obligatory. I must do 20, and I'm going to enter the final judgment. And the second district court of appeals said, no. The 1.090 does apply to Rule 1.280 and does enlarge the deadline by 5 days when it is mailed. And because it is enlarged, the trial court must follow the rules of civil procedure and allow 25 days. And because the motion for trial de novo had been filed within the 25-day period, the final judgment was removed, and the second district court of appeal directed the trial court to proceed with trial on this matter for a properly filed motion for trial de novo. We also see that other rules like 1.540 apply to arbitration judgments. I'm referring to the Preferred Mutual Insurance versus Davies case, 629 Southern 2nd 259. That's a fourth district court of appeal case. In that one, the appellant in that case missed the 20-day deadline due to a clerical error and subsequently filed a 1.540 motion to set aside verdict based on excusable neglect. The court denied that 1.540 motion, once again using that similar language saying, I can't do anything about this. I have to enter the final judgment. There's nothing that can be done about this final judgment for non-binding arbitration. The fourth district court of appeal reversed the trial court on its statement and confirmed it did have authority. Now, the reason why Preferred Mutual is so applicable to our circumstance, as Judge Stargel pointed out, the issue before us here today is the authority of the trial court. The fourth district court of appeal addressed that authority of the trial court on the 1.5 motion, saying that it could see no reason that the 1.540 motion could not be considered by the court. Again, it's not telling the trial court whether to grant or deny it, but it is saying, yes, you absolutely have that authority to consider a 1.540 motion for excusable neglect to set aside and remove a motion for to set aside a final judgment that was entered because the motion for trial de novo expired. And of particular note from that case, the court said, went on further to explain, because of the timing of the 1.540 motion, because it was before the final judgment, it acted in a manner like a motion for enlargement of time. Specifically said, we can see no reason why a Rule 1.820H judgment should not be subject to the clear provisions of Rule 1.090B of the Florida Rules of Civil Procedure. That is a binding case. It is not in conflict with Gambrel and must be applied and should have been applied by the trial court in this case, finding that the 1.090 motion for enlargement can and does enlarge the time period to file a motion for trial de novo.
Was Davis mentioned or cited at all in the Gambrel case?
It was not. It was not addressed or not referenced, and for logical reason, since no motions had been filed to invoke the jurisdiction of the court in Gambrel. The they're two separate issues. If you file a motion, you follow the Davis case. If you don't file a motion, you file the Gamble case. I see that I'm almost at my 5 minutes remaining. In that regard, I will reserve the remainder of my time, but ask this court to reverse the ruling of the trial court, find that the trial court had the authority to enlarge the period in which to file a motion for trial de novo, and find that the appellant's motion for trial de novo was timely filed with the enlarged time period granted by the magistrate.
Thank you, Mr. Hercombe. Mr. Weldon, the timer is ready for you, so you may proceed when you're ready.
May it please the court. My name is Richard Weldon, and I represent appellees Heidi Wolf and Joseph Wolf. I'd like to start with the plain language of Florida statute section 441035 and rule 1.820H, which are both clear and unambiguous. This section 441035 specifically states in pertinent part that an arbitration decision shall be final if a request for trial de novo is not filed within the time provided by the rules promulgated by the Florida Supreme Court. If no request for trial de novo is made within the time provided, the decision shall be referred to the presiding judge in the case, who shall enter such orders and judgments as required to carry out the terms of the decision. And Florida Rule of Civil Procedure 1.820H specifically states that if a motion for trial is not made within 20 days of service on the parties of the decision shall be referred to the presiding judge, who shall enter such orders and judgments as may be required to carry out the terms of the decision. Both the deadline and the directive to the trial courts are cast in mandatory terms. The use of the word shall in the statute meant that the court's obligation was a ministerial act with no room for discretion, and also a duty was imposed on the trial court, by law. That was looked at directly in the Gambrel case, which looked at the issue both in Citizens Property Trapeo as well as the 4th DCA case in Connell. And in Connell, the 4th DCA found that the entry of a judgment on a section 44103 arbitration award is a non-discretionary ministerial duty. And then as Gambrel is looking at Connell, Gambrel discussed that in Connell, neither party requested a trial de novo within 20 days. Thus,
Mr. Weldon, the issue I'm having with listening to you, read the express language of 44.103 is it uses the term provided by rules, plural, promulgated by the Supreme Court. It doesn't directly address or mention rule 1.820 in particular. It says rules. So why wouldn't 1.820 be able to be read with the general 1.090 subpart B, enlargement of time, in harmony?
In both Gambrel and in Connell, the courts looked at the explicit language of 44.1035 and rule 1.820H and said that both of those rule and statute made a mandatory, what Capel, the Florida Supreme Court kind of described in Capel, a strictly construed deadline. Similar to what we find in the Capel case, where we're talking about a proposal for settlement deadline. These are strictly construed by the legislature within the statute as to what deadline is obligated or mandatory based on the statute itself, on a clear and unambiguous way. So there's no interpretation there for the court to do. So in this situation, both 1.820H and 44.1035 specifically mandates to the trial courts that deadline. Otherwise, you would have a situation where the intent of the statute itself would be defeated by any party who wanted to have an extra period of time beyond the arbitration to simply file a bare bones motion for extension of time, and you defeat the purpose of the statute 44.1035.
Counsel, your premise assumes that if the legislature wanted to make it a hard and fast deadline, that they couldn't have done so. But they, as Judge Wozniak pointed out, they recognized the Supreme Court's authority to adopt rules. And those rules include enlargement of time. Why should they pick out that rule? All of the other rules that would apply, if someone's going to file, there's requirements on you. There's a lot of other rules that apply to that filing, and they use the plural. So why shouldn't these rules apply to enlarge time? If the legislature meant that under no circumstances could it have been extended, they wouldn't have had to include the language, would they? Saying that the rules promulgated by the Supreme Court would matter?
Well, in Gambrel as well as Connell, the courts, appellate courts looked at the issue on that, and in both cases, by both district courts, they found that the trial court had no discretion under these.
But nothing was filed there.
Well,
right.
Well, if we take the similar situation then in Capel, okay, when we're looking at the proposal for settlement offer of judgment deadline, okay, in that situation there, the Florida Supreme Court looked at it as a strictly construed deadline. And in that situation, even if there was a motion filed beforehand, okay, the court said that in that specific situation, that there would have to be a court order by the trial judge prior to that deadline, and there have to be a showing of cause under that scenario. Even if you were to apply it to now the 44.1035 and 1.820H, in this specific case, appellant still fails to comply with those requirements because there was never a court order granting a motion for extension of time. There was a magistrate's report and recommendations, but the trial judge declined to adopt those recommendations. To this date, as we sit here today, there is no court order granting a motion for extension of time. Secondly, on a de novo review of the record evidence, there was no showing of cause. If you look at the record evidence, what was presented to the magistrate was judicial notice evidence to show that the appellant, with just a little due diligence, could have complied with the requirements of 44.1035 and 1.820H. There was only assertions by appellant's counsel that just because of scheduling conflicts, they needed more time, additional time, in order to make a decision or determination on requesting a trial de novo. That's it. That's all that was shown. But if you look at the record evidence, it specifically shows that there were city council meetings already scheduled during that time period, that appellant knew about the arbitration decision or the arbitration date and when the arbitration decision would be coming forth for over a year prior to that time period. And the appellant's own city council rules allowed for them to make or to schedule a special meeting within two days. That's all they're required. So,
counsel, isn't that a different question? I mean, going to my original question, under that scenario, if the trial judge had looked at those facts and said, I don't think they're entitled to it, then we would be reviewing this under an abuse of discretion, correct? But instead, he looked at the statute, interpreted the statute, which gives us a de novo review.
And I agree with that, Your Honor. And trial court, looking specifically at Gambrel, which was relying also on Connell, specifically stated that the trial court had no discretion to deny the request in those situations because the act of entering into the final judgment was purely a ministerial act at that point, that there is a window of time from the time that the arbitration decision is open to the 20 days when the time period permitted to request a trial de novo. There's a 20-day window, and when that window closes, as a matter of law, the trial court has no discretion but to enter the necessary final judgments pursuant to 44.1035 and 1.820H.
So what rules promulgated by the Supreme Court do you think that the legislature was authorizing? Only one that said 20 days and that's it, period. That's the only thing that the Supreme Court was authorized to adopt?
The statute, is my understanding of the statute, says that if a request for trial de novo is not filed within the time provided by the rules promulgated by the Supreme Court, the legislature was looking for the Florida Supreme Court to issue a Florida Rule of Civil Procedure, which they did in 1.820H, as to what that deadline would be. And in the rule itself, it goes back into those mandatory terms of the decision shall be referred to the presiding judge, who shall enter such orders and judgments as may be required to carry out the terms of the decision. So again, I think the statute is relying upon the rule 1.820H, which again casts the same deadline and mandates to the trial courts as to that strictly construed deadline.
Throughout the rules, where the Supreme Court has adopted rules that say that certain filings have to happen within a certain time frame, shall is used extensively, but yet the extension of time rules also apply. So you're saying that this one is special only because the legislature said that they have to promulgate these rules, and they did, so that 20 days is sacrosanct.
What I'm saying is that the trial court specifically relied on the second DCA decision in Gambrill that specifically concluded that the statute says what it says, and so does the rule that implements its deadline. If a litigant fails to request a trial within 20 days of service of the arbitration award, the court shall enter a judgment on that award. I think the trial court relied upon the specific, plain, clear, and unambiguous language of both the statute, the rule, and the second DCA precedent in Gambrill to reach its order. And I don't think the appellant has met its burden to show that the trial court demonstrated error in making that decision.
Do you concede that even if we agreed with you that Gambrill applied and the facts of Gambrill applied, that we're not bound by that?
My understanding is that as of today's date, there has not been a Florida Supreme Court decision to determine whether or not the newly formed 6th DCA is bound by the 2nd DCA, 5th DCA, or any other appellate decisions, as far as I know. I think that would apply to any case that's before you at this point, Your Honor. I will note, though, at the time that the trial court made this decision and made his ruling based on Gambrill, that this was a Collier County case in the 2nd DCA, and the trial court was relying upon the 2nd DCA decision of Gambrill as he was required to do at that time. The other one point I'd like to make is appellant relies upon the footnote number 2 in Gambrill that that appellant makes a position that, well, the appellant in that case didn't specifically make an argument for 1.540. So in the footnote, the court says, well, we didn't make that determination then because it wasn't brought up. But that's not really what Gambrel says. If you read the language of it, the court says that talking about what the trial court did was attempt to graft an excusable neglect exception into a statute and a rule where none exists, which was simply unauthorized. And then there's the footnote. And if you look at the footnote, it says it was also never raised below. But in that footnote, it's saying, wait a second. We just said it in the actual opinion that this was unauthorized. It was simply unauthorized for the trial court to put into an excusable neglect provision that doesn't exist within the statute and doesn't exist within the rule. Then it says, and we are also noting that it wasn't properly raised either. But the court certainly addresses the issue as to whether or not the plain language of the statute and the rule should apply. And that's when, right after that, it goes into that very, very specific quote that the statute says what it says, and so does the rule that implements its deadline. And again, if a litigant fails to request a trial within 20 days of service of the arbitration award, the court shall enter a judgment on that award. So I don't think it's a, I don't think that footnote is such where you're just saying, oh, it doesn't apply at all because of that. That's not what the court's saying. It raised it. That's why it's in a footnote and not in the opinion itself. It's indicating that also that, but it makes a very strong and very clear ruling in Gambrel that the courts are bound by what the statute says. And if the statute says shall and the rule says shall, then the trial courts are bound by the legislative clear intent. In addition to Gambrel, we did raise the issue, just not to waive it, that in this case, the issue was never properly preserved for appeal. Appellant, in August of 2022, the Florida Supreme Court amended Rule 1.530, and specifically addressing how to properly maintain and preserve an appeal to challenge the sufficiency of a trial court's findings in a final judgment. The rule change became effective immediately. In that rule change by the Florida Supreme Court, 1.538, to reserve for appeal a challenge to the sufficiency of a trial court's findings in the final judgment, a party must raise that issue in a motion for rehearing under this rule. Appellant did file a motion for reconsideration on February 2nd, 2023. And an appellant argues that, you know, the title of the motion itself should not be should not cause an issue or problem with complying with the 1.530A. However, appellant never specifically filed a motion for a rehearing, nor did appellant within that motion for reconsideration request a rehearing. Never asked for a hearing, simply asked the court to reconsider. For that reason, appellant did not comply with the Rule 1.53A and thus did not properly maintain and preserve its appeal. Again, I would point out that if, and we pointed this out in the brief, that if this court were to determine that Rule 1.090B does apply, which in that the trial court would have discretion to extend the time period, which we believe Gambrel, Connell, and the other cases cited in our brief does not support. Again, it is clear that a motion for extension time would have to have been filed and a court order by the trial judge would have had to be entered prior to the expiration of the strictly construed deadline of the statute. Not only that, as mentioned earlier, a motion for enlargement of time would require a proper showing of cause before the trial judge. And the record evidence simply does not show that. The record evidence shows that with just a little due diligence, that the appellant could have complied with Rule 1.820H and Section 44.1035. Again, that's the in appellate proceedings, the decision of a trial court has the presumption of correctness, and the burden is on the appellant to demonstrate error. Appellant does not cite any authority that has applied Rule 1.090B specifically to the request for trial de novo deadline, and appellant does not cite to any authority to support position that the magistrate's report and recommendation totals the deadline to request a trial de novo. Nor does the appellant even argue that the filing of the motion for extension of time alone told the non-binding arbitration statute and rules deadline. For those reasons, the appellees would request that this court affirm the trial court's decision. Thank you.
Thank you, Mr. Hercombe. I'm waiting for the timer. There we go. 5 minutes and 13 seconds. You may proceed.
Thank you, Your Honor. Throughout the appellee's argument, he makes reference to numerous cases, which I know the judges have reviewed and have seen do not deal with the issue that is before this court, which is, do rules of civil procedure other than 1.280 impact and modify and address 1.280? The cases that plaintiff relies on, Gamble and the others strung out from that, all deal with cases where no motion was filed and it was simply no one filed anything within 20 days. You're
referring to 1.820.
Yes, I'm sorry, 1.820. Yes, Your Honor. Thank you. My apologies. Those simply don't have that. So none of those cases apply or are binding to this circumstance. The court should instead look to the cases that deal with the interaction of the rules of civil procedure with the rule that we're dealing with here today on the non-binding arbitration. I do want to specifically draw attention to the issue that was raised on the Gamble case to highlight that appellee's position on it, I believe, is inconsistent with the straight reading of the language of the court. The court, when it looked at all the facts in the Gamble case, specifically was addressing whether or not a judge has the discretion or the ability on his own volition to hear an argument on excusable neglect and whether he can deny a motion for entry for judgment based on arguments of excusable neglect. The court then says specifically, the court, in this case the trial court's attempt to graft an excusable neglect exception into the statute and rule where none exists was simply unauthorized. And that's important, and then it goes on to its footnote where it talks about no motion being filed, because it should be that way, that you cannot add language into a rule where it does not exist. However, 1.540 does have the excusable neglect language, and as we see in the as we saw in the preferred mutual case, you can read that rule's language, just like you can't add language into a rule, you can't take language out of another rule. We can read 1.540 in harmony with the non-binding arbitration rule and see that you can file motions that address arbitration awards and final judgments. In this case, 1.540 being used to find excusable neglect and setting aside award. So Gamble doesn't state that 1.540 cannot apply. It just says you can't build extra language into the non-binding arbitration rule for excusable neglect. The appellee's arguments with respect to whether or not the magistrate's recommended order, I think, is a bit distracting from the issue here. The trial court never ruled whether or not the magistrate's findings were correct. As this court knows, magistrates are given deference, and the issue is not, do you disagree with the magistrate's findings? It's, is there a reason to think that they had committed error? But here, the trial court specifically said it did not have the authority to grant an extension. And that's important because it has nothing to do with what was argued or the decision of the magistrate. It has everything to do with the trial court's belief that it never had authority to consider a 1.090 motion for enlargement of time. However, as we've seen under the rules, as we saw under the Herald case, 1.090 absolutely interacts with the rule of civil procedure for a non-binding arbitration, and absolutely is within the trial court's ability to extend that deadline. This issue is properly preserved. Appellee's counsel argues that the title of the motion is why there's no jurisdiction, but the case law cited Siegler versus Bell, a 5th District Court of Appeal case, clearly states that if your motion is filed after the final judgment, which this motion for reconsideration was filed after the final judgment, it is a motion for rehearing under the rule and applies. The title does not control. To borrow a phrase from the 4th District Court of Appeal, from the preferred case, there is no logical reason why Rule 1.090 would not apply to Rule 1.280, and no logical reason why the trial court could not extend the 20-day deadline set out in that rule. As such, the appellants are asking the appellate court to reverse the ruling of the trial court, find that the trial court had the authority to enlarge the period in which to file a motion for trial de novo, and find that appellant's motion for trial de novo was timely filed within the enlarged period granted by the magistrate. Thank you.